Beritahu sampai mulai. Sudah. Oh. Hello everyone. Good evening and good morning, ladies and gentlemen, colleagues of University Merdeka Malang, partners, and also participants. Greeting from Malang, Indonesia. I would like to say that in this condition, due to the pandemic corona, so I hope that all participants who attend this webinar stay healthy and safe. So next, I want to say thank you to everyone who, especially all participants, for joining our webinar today entitled Criminal Defamation and Free Speech in the Digital Age, Perspective from Indonesia and the United States, which is presented by the Faculty of Law, University of Merdeka Malang, in collaboration with American Institute for Indonesian Studies. To begin with our webinar, I would like to invite Dr. Setiono as the Dean of the Faculty of Law, University of Merdeka Malang, in order to give the welcoming remark. For Dr. Setiono, the time is and the place is you.
Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Okay, thank you. Assalamualaikum warahmatullahi wabarakatuh. Please be upon us. Good evening to the participation in Indonesia and good morning to the participants in the United States. Starting my report to the current webinar, thank you. Alhamdulillah Rabbil Alamin, that we are all given strength and health in a situation during the COVID-19 pandemic that hit around the world. To the Honorable Professor Joseph Katulin, thank you very much for your willingness as a speaker in this webinar. Professor Katulin is a senior fellow at the Center for Applied Cyber Security Research, and he is one of the professors at Indiana University School of Law. But again, many thanks for his willingness to be the best speaker in this webinar. Mr. Eka that is a lecturer at the Faculty of Law, University of Merdeka Malang, who is currently taking to doctorate in law. He is as a SGD candidate from the Malang School of Law at Indiana University. Ladies and gentlemen, the current theme is of this webinar is criminal defamation and free speech in the digital era, perspective from Indonesia and United States. This webinar was held in collaboration with the Faculty of Law, University of Merdeka Malang, with the American Institute for Indonesian Studies. Therefore, all this good opportunity, I extend my deepest thank you to the head of the American Institute for Indonesian Studies. Ladies and gentlemen, there are two variables in this webinar topic, namely criminal acts of defamation and free speech. These two variables have been regulated in the legal system in Indonesia. Criminal acts of defamation are regulated in Acts of Republic of Indonesia number 11 of 2008 concerning information and electronic transaction. Will Freedom 6 has been regulated in Acts of Republic Indonesia number 9 of 1998, governing freedom of expression in public. The implementation of these two acts often causes problems, debate regarding the meaning or interpretation of a term contained in the act. This can be understood because defamation is always associated with the victim's subjectivity. The question is, who are the victims of this defamation? An individual or a corporation or an institution? These two variables move to be one another against each other. Where the criminal act of defamation is strictly enforced, it often suppresses freedom of opinion. But on the other hand, when freedom of speech is released, will create a permissive situation for defamation. Therefore, it is very interesting to observe because many cases occur and often to pros and cons in the community. An example of a case that is very well known in Indonesia is the case of International Army Hospital patient who complained in hospital services but led the criminal justice processes. So naturally, the law enforcement is also interesting to be observed. In this topic, it myself having asked several times as a criminal law expert, put in the level of investigation in the police and examination at the court hearing. Ladies and gentlemen, in a social perspective, the criminal act of defamation is often used as a tool to fight for personal or group interests, even as a tool for political interests. Ladies and gentlemen, I think it is time for me to close my speech. It's been a pleasure being with all of you. Thank you for your attention. Congratulations on joining the webinar. Hopefully, we will all be given health in the COVID-19 pandemic situation. Good evening. Wassalamualaikum warahmatullahi wabarakatuh.
Okay, thank you, Dr. Setiono, for your remarks. And now we have come to the main session of the webinar, where we have two speakers here. The first one is Bapak Eka Nugraha Putra, who is a lecturer in law at University Merdeka Malang, Indonesia. His works are mainly on cyber law, free speech, and media law area. In 2016 and 2017, his research on spam as cybercrime and online consumer fraud, respectively, were granted Junior Lecturer Research National Grant by the Indonesian Ministry of Research and Higher Education, DIKTI. Eka is also working as a legal advisor at the Bully Aid, a platform that focuses on the protection of cyberbullying and online harassment victim. Eka is currently a Fulbright scholar studying for Doctor of Juridical Science at Indiana University, Morehead School of Law, United States. His dissertation focused on comparative research on Indonesia and several countries regarding criminal defamation and freedom of speech in the digital age. In 2019, he was awarded AISFIS Fellowship until 2020 for conducting his research criminal defamation and free expression in the digital age. The second speaker is Joseph A. Thomain. Good morning, Mr. Joseph. Joseph is a professor at the Indiana University Morrill School of Law, where he teaches information privacy law and internet law. Thoman has extensive experience in practice, teaching, and scholarship on free speech rights, particularly in online environments. He is also a senior fellow at the Center for Applied He also a senior fellow at the Center for Applied Cybersecurity Research, where his contribution include examining the relationship and often competing interests between speech and privacy rights, as well as the cybersecurity implication that must be considered when analyzing online privacy. His academic experience includes serving as a visiting assistant professor at the University of Louisville Brandeis School of Law, an associate professor at Florida Coastal School of Law, and an adjunct faculty member at Georgia State University College of Law and the University of Georgia School of Law. Both speakers will deliver their presentation for about 1 until 20 minutes each. And after we will have question and answer session for the participant. You can ask the question of give feedback through the chat, and later if we still have time, one or two participants can have time to ask and communicate with the presenter directly. And also I want to remind the participant who do not speaking, please mute your microphone. I will now give the time to Bapak Eka or Mr. Eka to deliver your presentation.
Thank you very much, Dr. Kade, for the introduction. I would like to do the share screen now. First of all, I would like to say that I'm really glad to be back virtually in Indonesia due to the pandemic and due to the distance. We have to do this through a webinar, but it is still very, very nice to see my colleagues and also the deans. Tiono, thank you for the wonderful welcome remarks. Thank you for Mr. Gali for helping in organizing this event. Thank you for Dr. Kadef to willing for being the moderator on this webinar. I would like also to thank to Professor Tomin, who is also helping me and working with me to, his contribution on my dissertation research, and also for this fellowship research, which is also, I have to say, address thank you to American Institute for Indonesian Studies for giving me a big support for doing this research, and also for Fulbright scholarship for support in my study in Indiana University Morrill School of Law. So I would like to start my presentation by doing a bit of introduction here. So my presentation and title slightly different might be from the dissertation itself. So this presentation today is entitled Online Criminal Defamation and the Chilling Effects on Free Speech in Indonesia. I hope that the chilling effect phrase here is not sounds too horrifying or terrible, but I'm going to show you to the participants today why I'm saying this might be a chilling effect for our free speech in Indonesia. The first my first slide would be stating what is the problem in here in Indonesia regarding to the free speech and also the defamation. So we have to go a bit on the history here. So we have been gained our independence in 1945, but not until 1998 we have been gained our true independence, and people in Indonesia were hoping that we will gain more freedom than we have before, because for almost 32 years we have been under authoritarian administration on the Suharto regime as the president. So whenever we gain the political reform in Indonesia, or we call it the Order of Reformation in 1998, there are a big hope and a lot of hope in the time. So it was reflected by the several legislation here, such as the Human Rights Act, Press Act, and also the Free Expression in Public Space Act. But if we look deeper into the freedom of expression practice in Indonesia, it still has a lot of problems. For example, the Indonesian Criminal Code Act is not yet amended to this date. There has there have been many drafts submitted through the years and decades, but people always reject it because the substance or the content in the legislation, in the such legislation, is always proposing the abusing power from the government, or even it might be violated the human rights in Indonesia, for example. So that's why we still have this obsolete, I should say, the obsolete criminal code acts, which is actually part of the colonialism from the Netherlands when they colonized us for almost 100 years. So the Article 310 and 311 and so on is part of the Defamation Act in Indonesia for the offline defamation. But then we've been facing another problem whenever government enacted the legislation called and Electronic Transaction Act in 2008. And although it has been amended in 2016, it still poses a lot of problem to the state. Even there are a lot of cases that I might be, if I have time, I can share some of my argument or my point of view on those cases. Uh, it's not that people or scholars trying to doing legal efforts or doing any efforts outside legal area to keep the freedom of expression practice is in the good way. But the thing is, there have been a couple of times the constitutional review in the Indonesian Constitutional Court in 2008, but all of them has been rejected the Indonesian Court or MK. Based on those bit of background, we can say that there are still problems in the legislation between offline and online defamation. A different legislation or distinction between the offline and online defamation in Indonesia, or should we not? Because of that, because that will lead to the another problem that is definition or the definition used with the false facts. What if false fact? What if it's opinion? No opinion speaks. I think that would be a bit, but the big or the main question I would like to pose such a democratic country, as they said, as the founding father said in our Indonesian Constitution in 1945, in Article 1, Section 2, that we are a democratic country. It subtly says that we are democratic country because the people's power in our hand. We have the power in our hand as the people, as the society. Whenever there is the legislation that criminalizing speech or criminalizing defamation, does it mean that our democracy will be relegated? Does it mean that our free speech value will be relegated as well? That is the first question I would like to pose. And then I'm doing a comparative approach to several countries, which is also the United States, and later will be explained by Professor Tomin in this presentation. But not only United States, I also doing a comparative approach with another countries such as Thailand and also Australia. And with that comparative approach, I hope that I can take some of the lesson or maybe some kind of suggestion or provide recommendation to Indonesia government through this research, how to consider and revising the online defamation law or defamation laws in general. What about the current states of our free speech today, at least until 2009 or last year? So I have two figures right here that I would like to present to you. The first one is from the BPS, or Indonesian Central Bureau of Statistics. The organization state that our democracy index in 2009 is rated at 74, the 2018. But if we look in the element of the civil society, they have decreased from 77.20 from 2018. Another organization is Freedom House, which is, if I'm not mistaken, is based in United States. They rated our freedom index is rated at 62, or we can say it's partly free, while the civil society element is rated at 32. What can we see from this both of figures is that both of these data shows that in terms of democracy, our political rights is guaranteed. There are no problem with our political rights. We have national election. We can vote for our Congress, for our House of Representative DPR in pemilu or election. We can vote for our president and vice president. We can vote for our governor, for our mayor directly with the election. There are no problem in the democratic process, such as in the political rights. But in terms of civil society, we still have a big problem in that. So this is why these figures show that kind of problem. And what kind of civil society problem itself, we have to take a look in this provision in these legislations. So I'm trying to put the online defamation first because later I'm going to the offline. But the first one about the online defamation provision, this is kind of chronological part that I have been made and I would like to show you. So in 2008, the Information and Electronic Transaction Act was passed as a law by the government, Indonesian government. And there are three deeds that mentioned in the Article 27, Section 3. The three deeds that can be fall into the category spreading the defamatory expression or stating defamatory expression in the cyberspace. The three deeds are to distribute, to transmit, and to make causes of accessible. But as we know that this is such a new norm in the cyberspace, and this is until to this date, this is the one single only legal norms on the Indonesian cyberspace. It should be there should be an explanation on those three Ds. What does it mean on the distribution? What's the meaning of to transmit? What is the meaning of to make causes to be accessible? Unfortunately, in the legislation on 2008, there are no specific explanation. It only says clear enough, but I have to say it's not clear at all because there are no explanation at all. So because of there were no explanation, we should ask to the lawmakers, if this the problem, if there are no explanation about what is the deed or defamation for the defamation that happens in the online realms, should we rely on our Criminal Code Act because our system, our legal system will be central, will be put the central to the main source as to the legislation, not like a country in the common law. So can we rely on the definition of defamation from Article 310 to Article 321? There were no explanation as well. So it's remained unclear to this date to whenever this legislation passed in 2008. And if we're trying to put that logic by the definition of defamation in the Criminal Code Act, the problem is the IET Act 2008 have the legal subject, consider the legal subject, there are two, which is person and also a corporation or company as a legal subject or legal entity as a legal subject. But if we rely on the Criminal Code Act, legal entity is not recognized as a legal subject. So it is not an inappropriate, reliable legislation whenever we say online defamation should rely on the Criminal Code Act or KUHP. So that was the part of the 2008 version. And then on the very same year when the legislation was passed, there were there was one constitutional review. It was filed by a journalist named Iwan Piliang. He was a journalist who was faced a defamation charge as well because he wrote a news story about a politician or entrepreneur, and then and then the person did not use the right to answer, which is a mechanism that provided in the Press Act 1999, and instead he was reported to the police and he had to face a criminal defamation charge. But the thing that I would like to say here on the Constitutional Court in 2008 is that the judges or the court says that this Article 27, Section 3 is not against our Constitution, which means that the courts argue that this Article 27, Section 3 is needed because Indonesia need the extensive regulation for online defamation, because the definition of in front of public eye in the Criminal Code Act is not fall into the category in the cyberspace for defamation in the cyberspace. So that's why the extensive regulation is needed to be regulating for the online defamation, while the offline defamation will be regulated in the Criminal Code Act. Okay, so that's it. But another problem or another statement or another argument from the court is that it should be a criminal complaint based, because only the person who feel offended should be report or file lawsuit for the online defamation or offline defamation. Going next to the 2016, 8 years after the constitutional review and also the legislation of the 2008 version, the deeds are now explained. So there are explanation section which provide definition of the to distribute, provide the definition of to transmit, and also provide the definition of causes to be accessible. And then online defamation is officially now officially as a criminal complaint base. But still, it is still an online criminal defamation. And I think by just reducing the prison term from 6 years on the previous legislation to 4 years on the latest amendment in 2016, it's not posing a solution for the problem here. It just keeping the problem right there. It just still exists for the problem, and still the legal entity is still not recognized as a legal subject, because until 2016 and even until today, we still, in our Criminal Code Act, we still don't recognize legal entity for as a legal subject. We only recognize person, naturally person in Dutch, or person as the only one as a legal subject that can do a criminal act, that can do any legal acts. What about the offline defamation in the KUHP or Criminal Code Act? I'm trying to look deeper into the article. So as I said before, there are a couple of articles about defamation in our Criminal Code Act. There are 311 until 321 for the general defamation. There are a lot of special defamation, but I'm just gonna put my focus here on the general defamation. But I only put 3 in here because at least this is like the most common defamation provision that usually used for offline, especially. So Article 310 is libel and slander. So whenever it's a written and oral defamatory expression, it will be fall into the category of Article 310 on our Criminal Code Act. It says more or less that whenever someone deliberately pointing for someone do specific acts, and then it made in front of the public eye, it will be libel and slander, something like that. And then false accusation, if it's then proven that it is a false statement of facts, and then it must be a false accusation, or in Indonesia we usually call it fitnah. But I think one of the problem for our offline defamation in our criminal code is in the Article 315. So simple defamation or insult. So the scholars have been make an example for Article 315, such as name calling, such as name calling, like you comparing you with an animal, for example, or making fun of your name, or making fun of your physical appearance, something like that. I'm not saying it is correct deed. I'm not saying it is a good act or a good deed. It is false, but we don't have to punish the person who do that to us by using the state power or the state intervention, by using the criminal defamation and then put them in the prison. So having this article in our criminal code is actually a big problem, at least for me, from my point of view, because whenever we feel offended just because someone insult us, can we just put them into the prison? I found it ridiculous for me. I found it's not a good way or not a good thing to let them have expression for among ourselves. So that is the problem what I see in this Article 315. So I think let's just move on to the rubber provision. Some of you, especially in Indonesia, might have known about this term that called the rubber provision. So um, the rubber provision here is usually used by the media and also people to call that this provision, I mean the Article 27, Section 3 IAT Act is actually very elastic to be pulled to anywhere, wherever the plaintiff wants to go. So for example, if I feel insulted by someone name calling me or comparing me to an animal, I feel offended. Although it might be not affecting my reputation, I can use this. I can pull this provision so elastic so it will be go into my interest. It will be go into my my I mean I can say that it violated my rights and so on. So this is the problem, because even though there have been explanation for the deeds, these three deeds in the 2016 amendment, as I said before, but it still poses a problem. Let's see one by one. So to distribute means, based on the explanation section of the 2016 amendment, distribution means that one person sending electronic information to many people, so to a mass or a group of people. So for example, what I am doing right now, I am one person who is sending, or who is talking in front of my Zoom screen or Zoom meeting to 150 people of you as a participant, or the audience of this webinar this morning or even in Indonesia, is part of the I'm distributing my electronic information. That's the example of the to distribution. And then what about to transmit? So transmission means that I am an individual sending another electronic information to another person, to another individual person. So for example, if I am sending an email to Professor Tomain, that will be transmission of electronic information. If I'm sending a text message to Dr. Kade, that will be an example of transmission based on this legislation. But there are no problem with the definition, but the problem is lies because it put as the required element for defamation. Why I've said that? So as if you remember what I said on the previous slides before that, based on the 2016 amendment, Article 27, Section 3 of the IET the definition of the defamation should rely on the Criminal Code Act, which is in the Article 310 and Article 311. So they are no longer using outside of these two articles. They only use that the definition of defamation should rely on the Criminal Code Act, which is Article 310 and Article 311. That's it, just two. But in the Article 310, it says that defamatory expression should be made in front of the public eye. If I am using distribution, or is someone using defamatory in cyberspace as a distribution, that would be not a problem. It still fall into category of public eye, in front of the public. But what if someone sending a defamatory message or defamatory content by transmission, which means sending one person to another? It is a private message, not a public message. So only one person will receive the message, only one person who will read the electronic information. But why they do still have this transmission did in the Article 27, Section 3, but still rely on the Criminal Code Act, which is obsolete, and still say it should be made into front of the public eye. I mean, in front of the public eye, physically in front of the public eye, is different. It's different with the transmit here because it is in the cyberspace. So it just not compatible comparison. It's just not a good way to find the definition for the transmission, especially when we have to rely on the Criminal Code Act. But that's what the legislation says. And I think that's why we still found a lot of cases that make us confused whenever we see the legal process or even also the court decision. Another deed, or the last deed in this article, that I would say still pose a problem is the causes to be accessible. This is a big problem because if you read the explanation in these deeds, it says that any acts that's not fall into the category of distribute and transmit would be fall into this category. So I can say if I am using a Wi-Fi connection in a restaurant, and then I'm sending a defamatory message or email to another person, the person who feel offended can not only can he report me to the police or filing lawsuit for defamation to me, but he also can do that to the internet provider. He also can do that to the restaurant where I'm sitting at and I'm sending at and I'm using the connection from that restaurant, because this definition for the culture to be accessible is still too broad. It's still too general. So it's impossible to using this kind of definition just because they want to absorb any acts that do not fall into the category of the first two. So I think that's the problem with the online defamation and the rubber provision in here. What about the cases? There are 4 cases that I believe most of you have known, and because these are popular cases, the last two, the bottom two even is the latest case that I found. So these are in the top left is the Prita Mulyasari case in 2008. It's the first case that happened on the online defamation whenever the IET Act was passed as a law. And then in 2014, there was a student, ironically a law student in Yogyakarta, who faced a defamation charge because she was she was allegedly defame a city, a Jogja city. So, and then we will see what is the content, what is the message later, and then the left bottom will be someone who is put on Instagram story to asking another policeman wife to repay the debt through Instagram. She has to make the public because the one who has the debt is blocked in any communication she can contact you. One of the most ironical cases is here because whenever there is a professor in Universitas Syah Kuala Banda Aceh is proposing a criticism in the WhatsApp group, and then he had to face a criminal defamation charge. Okay, I forgot to say in the very first slide or in the beginning, I'm going to explain some of the detail in this case, and I'm going to mention a couple of names in this case regarding this case, but it is part of my academic argument. It is part of my research and my interest in this area. So it is not means to be intervening the legal process or any other acts that might be harmful. It's purposely only for the educational purpose. So this is the statement from the 4 cases that happened. So Prita says in the mailing list that the hospital processed a fictional lab result. What about the Florence, the law student in Yogyakarta? She said that the people in the city are poor, stupid, uncivilized. Anyone should not live here. Let's just stop right there. Prita says that the hospital did not mention specific name. Yes, she did mention a specific name of doctor who was giving her a medical checkup. But whenever related to the fictional lab result, she only says the hospital, not the doctor. Florence, she said that the people in this city are poor, stupid, uncivilized. So she did not mention any specific name because she didn't know who were the names of the person who she was faced into that day. Whenever she got caught in the line, whenever she went to the gas station, she felt angry, she felt mad, and then she posted into the social media path. But because she didn't know the name, she just called or she just text in the social media, the people in the city are poor and so on. The problem in here is, can we say that hospital or city has a feeling to be offended? I would say no. How come? How come a hospital or city, Yogyakarta city in this case, can be feel offended? And if so, who should be the representative to be filing the lawsuit for online defamation or offline defamation, if it's written or oral expression. And even so, again, if it's offline defamation, our Criminal Code Act does not recognize legal entity such as corporation, company, organization, country, state, province, city, district. Any of the legal entity is not recognized as a legal subject in Indonesia in our Criminal Code Act. It is indeed recognized in outside of the Criminal Code Act, but for the terms of online defamation, as we have to rely on the Criminal Code Act in the 310, again, we can do this on these two cases. But what happened is still that these two person, Prita and then Florence, still have to face defamation charge, and they were found guilty. Kind of ironic. So, and then the third one is the expression from the Febi Nur Amelia. I will explain later more specific. And then the latest one is from Professor Saiful Mahdi, Dr. Saiful Mahdi, who is a professor in Universitas Syah Kuala Banda Aceh. So he said that I have received sad news about the death of common sense in the leadership ranks. So in the Febi Nur Amelia case here, in the third one, she mentioned specific name, yes. But in the latest case, in the Saiful Mahdi case, he did not mention any specific names. He only mentioned leadership rank of engineering school. Okay, let's see how specific elements on this. So the Saiful Mahdi case, or Dr. Saiful Mahdi case, has been in the process of appellate court. The last time I checked, it has been on the appellate court, and it was he was found guilty on these two court decisions. But if we read the whole court decision, especially on the first degree court, there are contradictory witness statements. There are different from the East statement. I don't know why this happened, but someone says it is a false news. Someone says from the witness it is defamation, but someone says from the witness it is an accusation, which is for each of these has a different legislation, has a different provision, or has a different criminal provision. And again, if the dean felt that the campus that he felt that his reputation was tainted, the problem is the message from Dr. Saiful Mahdi is only mentioned leadership rank of the engineering school. He didn't mention the dean. So it could be the dean, it could be the vice dean, it could be any on the leadership ranks. But when he said that he felt that his reputation was tainted, it is the dean itself, or the campus, or even the engineering school that reputation is tainted. It's not clear. And there was no deeper investigation from the judge, from the court, from the prosecutor to be checked, or to be more making sure about these elements. And can we say that the death of common sense falls into the defamation elements? From what I read from the case or the court decision, he was texting this in the group because it was part of his background of knowledge in statistics. So he found the potential of mismanagement of civil servant tests, recruitment of a professor and lecturer in that university, and he found the strange fact based on his knowledge of statistics, and then he said that it might be potentially abuse of something of mismanagement here, and then he says a death of common sense. But it's not. I don't think that it should be fall into defamation elements, and not to mention that also distribution and transmit, which is he only did the distribution because he's sending the message only in the WhatsApp group. He did not sending the message to the dean or to someone specifically in this case. The more strange case, which is not decided yet, is the case of Febi Nur Amelia. So Febi was lending the money, give the money to be borrowed by another person, another housewife named Fitria. Fitria is a wife of a policeman. The amount of money is 70 million in rupiahs, and then it was said to be processed for the promotion of her husband. But then whenever Fabi was asking for repaying the debt, Fitria, the plaintiff, always blocked the all communication medium. And then she was reported to the police. Filing the lawsuit, had to face the defamation charge. But the problem in here is that whenever these two persons having debts as a private matter, why the state should interfere with the criminal defamation? Why should be there an intervention from the country or the state to be punishing someone by putting them into the prison just because it is caused from the private matter, which is debt or repaying the debt? And if so, what is the loss of the plaintiff here? What is the loss of the plaintiff, and what is the loss of the state because the state wants to interfere this case? So I found this strange in terms of defamation. Why still we have to use the criminal defamation while this is a private matter? So I have a bit of comparison between Indonesia and United States, but it might be explained further by Professor Tomain. In the left side, I said that this is the part of the case that I mentioned before, how it went from Prita Mulyasari case in 2008 until she eventually found not guilty, but after judicial review in 2012. So after 4 years, she finally free from any of lawsuits and the other two cases that I've been mentioned on. But if we take a look into the United States legislation here, there are Komunikasi Decency Act in 1996, and it has Section 230, which is provide immunity or provide protection for information content provider. So, for example, if I want to file a lawsuit into a website, I have to make sure that the content that I found it defamed me or offended me, it was published with knowing falsity or reckless disregard for the truth. So there are part of contribution, or there are part of liability from the internet content provider or from the media that made it was published and then directly attacked me. This was found in the case of New York Times versus Sullivan. So the New York Times is the newspaper in the United States of America in 1964. So Sullivan was feel offended by the ad during the civil rights movement in 1960s, and then he was filing the lawsuit because he was the city commissioner. So he was the public official during this time in the Alabama. So the actual malice standard here is applied to public official or public figure because it should be the court says that it should be published with knowing falsity or reckless disregard for the truth. So New York Times was found that at least has a contribution to the publication of the ad that then offended Sullivan as the city commissioner at the time. So it also has to be a false statement of fact, because in the ad that was published on the New York Times, there were several minor accuracy that found it by the court. But this standard, the actual malice, was not an appropriate standard that can use for private individual, as found in the case of Robert Gertz versus Robert Wells in 1974, because Gertz was nor a public official or public figure. He was a private attorney who was hired by a family for the rape case for the case of the son at the time, and the judge argued that it was for private individual, state may not impose strict liability on the news media. But then another case in the 1997, when I say the Section 230, it was applied here. So Ziron was filing a lawsuit to the AOL because of malicious hoax by anonymous user, because he didn't know who was posting the defamatory content in the AOL forum, internet forum. He was filing a lawsuit to the AOL, but AOL was found not guilty because it was immune under the Section 230 because there was no contribution or liability found by the AOL as the website or the information content provider. So these three is some of the landmark cases in the United States regarding the online defamation. Again, so if we back to the
Mr. Eka,
problem.
excuse
Yes.
me.
Yes.
I remind your time. Yeah, you
Okay,
still
yeah,
have.
yeah. Yes,
Okay.
thank you, Dr. Kati. Okay, just one last slide. Okay, so with that explanation, it is hard to say that we still. I should say that we still can we say that we still have a lot free speak in here? Can we still have the democracy principle in here? Because there are a lot of signs from this, at least from these two latest research from the YLBHI or Indonesian Foundation of Legal Service that provide sign of the authoritarian administration, or even the academic freedom violation, which is also part of freedom of speech in Indonesia. So these two research you can find it here in the link I provided in here, and you might be Google it. You can find what is the, can we say that we still have free speech in Indonesia based on this research and based on the last lot of cases that I have been mentioned before. And my findings so far, because this is still an ongoing research, is that I believe that, although I put question mark here, but I believe that criminal defamation will be harming democracy. It will be punishing people who wants to give an expression, who wants to give a criticism to the society, to the government, for example. And if we're not allowed to be voicing our opinion or criticism, what is the point of democracy in here? And with the case of the too much or too many criminal defamation, we will have over capacity in our penitentiary, and it has been proven, because in 2018 our Ministry of Law and Human Rights has been said that we need a lot of budget, a much budget to be funded for the capacity in the penitentiary, which is not, because we find uh, more overcapacity in the prison, in the penitentiary, but we still have to do much budget for that. And there are a lot of options that I could say for the recommendation. At least one of them would be repeal the criminal defamation provision and using the civil defamation provision, and also to be giving the capacity building for the uh, prosecutor, judges, and also the police. So I think that will be the end of my presentation. I don't want that Indonesia going back to the past whenever we are under the authoritarian regime. So thank you so much for the uh, chance. I will give back to moderator Dr. Kade. Thank you.
Okay, thank you, Mr. Eka. Now I shall give the time to Professor Joseph Tomain to deliver your presentation.
Thank you so much, Dr. Kadek. Thank you, Eka, for inviting me. Thank you all for coming. My name is Joe Tomain. I teach at the Indiana Law School in the United States. I also want to thank Noah Holloway, my research assistant, who helped me prepare my remarks today. So thank you all. I'll keep this brief, and I want to do two parts for my talk. The first part, the large part, is going to be mainly descriptive of the development of criminal defamation in the United States. And then very briefly, I'll conclude with a normative statement. And before I mention those remarks, there's some things that I wanted to highlight from Eka's presentation that I thought were wonderful. First, just his title did a nice job summarizing this issue, talking about the chilling effects of online criminal defamation. In the United States, the phrase chilling effects has special significance when we talk about the regulation of speech. We are concerned in the United States about government suppression of speech and the threat of that. And so therefore, laws that prohibit speech, either civilly or criminally, could have a chilling effect on speech and therefore on democracy. So I think Eka did a very nice job by putting that in the title. And then secondly, I thought Eka did a really nice job by highlighting the importance of criminal defamation in the online context. Because one thing that we have seen in the United States is somewhat of an increase in criminal defamation prosecutions since the development of the internet. This is not to say this is a widespread problem, but nonetheless, it has increased with the role of online communications. Last point, and Eka did a very nice job of this too, highlighting that in the United States, in order to succeed on a defamation claim, one element that you must prove is that there was a false statement of fact. And so some examples from Eka's presentation that would not qualify as a false statement of fact: calling somebody stupid or uncivilized or the death of common sense. None of those phrases are false statements of fact. They might be derogatory and mean, but they would not qualify for defamation in the United States. So criminal defamation in the United States dates back to England in the Star Chamber that existed from the 15th to the 17th centuries. And it was mainly used to suppress opposition to the political powers that be. In the United States, we had something called the Alien and Sedition Acts of 1798. These were eventually repealed, but these were also attempts to suppress political opposition to then President Adams and the Federalist Party. When Thomas Jefferson won, those laws were repealed. Let's fast forward to 1961. There's an organization in the United States called the American Law Institute. They have several roles. One of those is creating a model penal code. And I want to show you a quote from 1961 when they were considering whether we should still have criminal defamation in the United States. And it's this first one here. In their tentative draft of the model penal code from 1961, the authors wrote, "It goes without saying that penal sanctions cannot be justified merely by the fact that defamation is evil or damaging to a person in ways that entitle him to maintain a civil suit. Usually we reserve the criminal law for harmful behavior which exceptionally disturbs the community's sense of security." This is a good moment to pause for a moment. As I mentioned, criminal defamation in the Star Chamber was mainly used to suppress political opposition, but there was another justification for criminal defamation laws, and that was to avoid breaches of the peace. The United States brought over from England and Western Europe the concept of duels to protect one's honor and also to resolve political disputes. And so before the rule of law was established in the United States, dueling was a main way for people to seek justice, and criminal defamation was seen as a way to avoid duels. Now, in 1961, the American Law Institute realized that by this point in our history, the rule of law had been well established, and we didn't need criminal defamation to avoid the risk of a duel. That just wasn't happening by the time the Model Penal Code authors wrote that document. Becca already introduced us to a unanimous Supreme Court decision from 1964, New York Times versus Sullivan. This dealt with civil defamation. It dealt with the civil rights movement, as Eka pointed out. And in that case, the court held that there has to be a false statement of fact, as we discussed. And then secondly, that if you're making a statement about a public official, in order to find civil defamation liability, you have to establish that the statement was made knowing that it was false or with reckless disregard to the truth. That same year, another important decision was handed down by the Supreme Court called Garrison versus Louisiana. This is also a unanimous Supreme Court decision from 1964. And in this case, the court held unconstitutional the state of Louisiana's criminal defamation statute for two reasons. One, it didn't require that the statement be false. And they held that just like under civil defamation, in order to succeed on criminal defamation, it has to be a false statement of fact. Second, the statute was also unconstitutional because it didn't incorporate the actual malice standard from New York Times versus Sullivan. In other words, you had to prove that the statement was made knowing that it was false or with reckless disregard to the truth. Now, Garrison versus Louisiana did find the state of Louisiana's criminal defamation statute unconstitutional, but it did not hold that all state criminal defamation statutes are unconstitutional. It just held that the New York Times rules had to apply, false statement of fact and actual malice. And the court in that opinion also expressly said, we're talking about issues of public importance. We're not making any statements on purely private libels or defamations. And I want to show you one quote from that decision. So from Garrison versus Louisiana, the court said, "For speech concerning public affairs is more than self-expression. It is the essence of self-government. The First and the 14th Amendments embody our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. and that it may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. So again, we see these very strong protections for speech in the United States, especially in the context of matters of public interest. There was 2 justices who agreed with the result of Garrison versus Louisiana, but they would have gone a step further. They would have held that all criminal defamation statutes in the United States should be unconstitutional because we have civil defamation and we no longer need criminal defamation. It oppresses political speech, and the justification of trying to prevent duels for breaches of the peace no longer made sense. Today, there are still 24 of the 50 United States that have some criminal defamation statutes on the books. And while the common theme and perception is that criminal defamation is used to suppress political speech, there was a scholar in Wisconsin who did an empirical study of criminal defamation prosecutions in the state of Wisconsin from 1991 to 2007. He found 61 prosecutions there, but he found only 1/5 of those prosecutions dealt with issues of public interest and dealing with public officials. He categorized the other 4/5 into different categories. One category was failed relationships, what we would call today revenge pornography or non-consensual pornography. A couple would break up and then maybe they would post nude images or videos online or other places. There was also a category of cases dealing with somebody that might have been fired from their employer, and then they would engage in this. And so what his last name is Pritchard, what Pritchard sought to establish in these 61 prosecutions in the state of Wisconsin from 1991 to 2007 is that most of them had nothing to do with the main concerns of criminal defamation. And his argument was that perhaps criminal defamation prosecutions do play a role in areas that we do want to seek justice, such as revenge pornography or posting information about a former employer, for example. Most recently, there was a case in New Hampshire that is still ongoing. It was the second time an individual had been charged with criminal defamation. One of those 2 times, it was based on statements he made against a local police officer. A federal trial court here recently ruled on procedural grounds that the case can go forward, but has not reached the constitutional issue of New Hampshire's statute. And again, I want to highlight ECA's emphasis on the role that the internet plays in criminal defamation, because in the United States, we are seeing somewhat of an increase in these prosecutions since the rise of the internet. And so that really kind of provides a very brief description of criminal defamation in the United States, dating back to the Star Chamber to today, where we still have 24 states with these laws on the books. And with that, I just want to provide some brief conclusion remarks. Like ECA, I think we can see that criminal defamation can be harmful to democracy. Even if the Wisconsin empirical study is correct, that over a period of 16 years in Wisconsin, 4/5 of the cases didn't deal with political suppression, we do see a rise in these cases with the internet. The New York Times versus Sullivan case that ECA mentioned is important because it deals with civil rights. It was an attempt to silence speech in the civil defamation context. And some have said that there is an inextricable link between free speech and civil rights. The New York Times versus Sullivan case helps establish that principle, as does Garrison versus Louisiana, because in that case, I didn't share the facts with you, but ultimately a prosecuting attorney accused 8 judges of being lazy. And so we can see this inextricable link between free speech and civil rights. And criminal defamation is a threat to free speech, and therefore it is also a threat to civil rights. More importantly, criminal defamation is not necessary today if it ever was. We have civil defamation claims that are available, and we have general criminal laws such as harassment and disorderly conduct, such that we don't need to try to put certain things into a criminal libel prosecution. We have other criminal defamation laws. So I think one of the real beauties of this conversation today and Eka's great work is to show that there are lessons for both the United States and Indonesia and other countries to continue to learn in limiting and perhaps getting rid of criminal defamation altogether. That's it. Thank you so much.
Thank you for both speakers. Now we come to the question and answer section. Before that, I will try to remind the participant to fill in the form in order to get the A certificate. Mr. Eka,
Yes.
because you can see in the chat the question, maybe you can read.
Oh yeah.
Yeah.
Yes, I found this. I found the first question.
Aku nggak lihat mana.
Okay, so this is from Miss Tirza Sharonli. I'm not sure if you're addressing this question to me or Professor Tomin, but maybe Professor Tomin can answer this question as well. But I'm going to answer this first. So I'm going to read the question here. So if there's a case that a health professional spread or share news or statement which at the time cannot be verified, but most people believe and the other don't trust it and reported to legal institution that it was a hoax, finally he was punished. 1 year later, he was proven innocent. So what is the question here? I'm sorry. Is it a question that are you saying that it should be a defamation or not, or it should be a hoax or not? If you can elaborate this question, I will be happy to answer this. Mr. Rizal? Okay, did we break the IET Act? Okay, so, okay, because you mentioned that it was a hoax, so there is another problem in the IET Act. So the problem in the IET Act, we don't have the specific provision for hoax. What we only have is a fraud, which is different with hoax. So whenever you see the article in the IET Act, Article 28, Section 1, it says berita bohong, which is in English will be hoax, but it's actually different because the rest of the article says berita bohong untuk yang dapat menyebabkan kerugian konsumen di internet, or false news that can harming the consumer in terms of online trade. So it's not a hoax as in term harming the people in terms of socially or something like that, but is that it was a hoax for in terms of consumer fraud. So it should be a consumer. It should be the law. It should be an element of the loss from the consumer whenever we would like to apply the article of 28 section 1. But to this date, we don't have any specific provision for hoax in terms of online realms. What we only have is the spread the false news or hoax in terms of offline in the Criminal Code Act. But for online, unfortunately, we do not have it. That's why whenever I show you in the slide that there was a telegram letter from the Indonesian police chief in April 4, they were using this article of the hoax, but they actually do not have it. So that is the problem in terms of the hoax article. So I don't think that he break an IET Act in terms of hoax, but if the verification is the share news statement of verification, it should be not a hoax it should be not a defamation as well. So that is my answer. I hope that's an adequate answer. Okay.
Okay, Mr. Eka.
Yes.
Now there is another question you can see from Yadin Delis Putuhena Unmer.
Okay, yeah.
You can see in the chat, please.
Yes, okay. Riyad Putuhena asking that contradiction between freedom of speech and right to honor. Yes. So I think that is the main element. So I should say that uh, right to honor and reputation is part of the defamation provision that has been mentioning by the state. But in terms of this, even if the contradiction, even if we want to say that we have the freedom of speech, it should be not violate someone's honor or reputation. But the thing is, in Indonesia, we don't have specific tests like the United States does. Like they have this actual merit standard test for the public official or public figure whenever they do the job as a public official or public figure, or the lower standard, which is not actual malice whenever defamatory expression was addressed to private individuals. That's a thing that we don't have. So if we want to try to resolving criminal defamation case using the civil law, so we actually do have it. We actually do have it. So if you're looking the civil law code or KUH Perdata, we have in Article 1365 and Article 1372. But the legal investigator, the police, the court, the judge, the prosecutor never used that, as far as I know, never used that articles in the civil law code to the state for defamation. They always want to use the criminal defamation provisions, which is I found it's odd. It should not be the criminal. Instead, it should be the civil law process, because it's a private matter. As I mentioned in the case of Fabian Amelia. That's my answer for Riyadh. And then
This is the in Indonesian version. Maybe Mr. Eka. This is she asked
yeah,
to Mr. Eka. Okay.
yeah, there was another.
From Adelia.
Yeah, there was another question, Dr. Kadir, from Belinda, from at the above, before the Adelia's question. So Belinda asked if in the draft Criminal Code Act, article insulting president and vice president reappear, whereas it was cancelled or called invalid as a law by Indonesian Constitutional Court. What do you think about the effort of the regulation? I would say I disagree with that effort from the government to drafting the new criminal code, but still using the obsolete and uh, old provision to harming our human rights and harming our free speech in Indonesia. It is a false and it is a wrong move. And I don't think insulting, if not only insulting president, I don't think insulting someone, as I said in my presentation before, it should be punishment by criminal defamation, or we should be putting into the prison. It's not part of the criminal act. It should be part of our free expression and free speech. It might be unethical, it might be wrong, but it's not a false statement of facts. It's not a false accusation. It's not harming any reputation or honor of someone's, unless they can prove it. That will be a different story. But I don't think it's a good move from the government, from the lawmaker, to be putting in here. And it just emphasized the point that I was pointing out about the democracy, that we might be facing the relegation of our democracy and free speech in Indonesia, because we are getting the government who doesn't want to be criticized, who doesn't want to be sharing the idea with us. And I also get this argument from the whenever I'm doing this research in the United States. It's called the marketplace of ideas. That's the marketplace of ideas should be part of whenever any person from the society should be freely voicing their ideas and expression. So then the government could see which one idea is best, and then they can take it into account to be pulsing, to be mitigating, or to be creating a policy for a better country, or for a better state. So that would be my answer to Belinda.
Okay, Mr. Eka, there is an Indonesian version from
Yes,
Adelia. Maybe
Adelia.
Professor Thomen also want to hear regarding her question, is regarding the urgency of regulating Article 27, paragraph 3. It is necessary to differentiate regarding criminal prosecution only if it causes measurable losses such as material losses and immaterial losses that follow material losses, or can still include personal or emotional harm. That's from Adelia. Okay, time.
Okay, my answer to Adelia's question is that because we still because you mentioned Article 27, Section 3, which is I I can assume that this is part as the criminal defamation in general. So I would say instead of using distinction between material harm, material loss or immaterial loss in here, we should using the civil law, civil law, so civil defamation instead. So just revoke the whole article or the whole section in the IETX, just using the private law instead. So it would be more appropriate law. It would be more appropriate provision than using, like, in Indonesia we call it pidana denda, but it's not a good measure to measure the harm from the plaintiff. It should be the civil law defamation instead of the criminal law defamation. And then there also another question, Dr. Kadek, from Mirza Hardian. Well, my simple answer will be the digital literacy. That's the most simple answer for me. It should be digital literacy that we don't have. I think we don't have that holistic part or that holistic movement in Indonesia to the state. Although we have the Indonesian Ministry of Communication Informatic, but I don't think it's really widespread in the whole area of Indonesia. That is the problem. Even there has been a research on this that hoax are becoming more imminent in Indonesia because the lack of digital literacy in Indonesia. That is the main solution for that problem. That's my answer for Mirza. Dr. Kade, I answer all of the questions so far.
Yeah.
Yeah. So I don't know if Professor Min might want to add some answer to this question.
You please, if he has time.
Yeah. So and I apologize if I mispronounced the name, but I think Mirza has a really wonderful question that extends our conversation here. The way that I interpret the question, and I could be wrong, but when Mirza mentions how do we protect people from hoaxes, I'm thinking of the current topics of misinformation and disinformation, especially in politically charged contexts. I think that's a really wonderful question. We're certainly facing a lot of those issues in the United States that I can speak to, and it's a real problem. And I don't think that criminal defamation is the way to solve it. A couple possible ways to think about hoaxes or misinformation and disinformation. We could think about access to private information as perhaps one way to deal with that. When you think of the Cambridge Analytica scandal in the United States election in 2016, they were able to have a very strong effect by micro-targeting voters because they received so much information from Facebook accounts. It's something like 300,000 people took a quiz, and based on that, Cambridge Analytica was able to get up to 80 million people's information off of Facebook. And then through that information, they were able to engage in a hoax or misinformation or disinformation for political purposes. So if your question is about that kind of hoax, I think it's really important. I don't think that criminal defamation is the solution to that because of the risks of political suppression through criminal defamation, but it's a really important issue that extends beyond our conversation today.
Okay, thank you, Professor Tomain, and Pak Eka to give answer related to Birsa question. It's very, very useful. And now I think there is no question anymore, Mr. Eka. So we have now to come to the end of the webinar today. So we have already discussed many things on the perspective of Indonesia and America on defamation law and regulation. We hope that everyone, all those participants who attend this webinar, gain new knowledge and a better understanding on this topic. On behalf of this committee, I would like to say thank you for the presenter and for the participant and for the what do you call to both webinars. So I see in the next webinar, and thank you very much and good evening. Mr. Eka, do we have like you say later on, you want to make
Yeah.
a picture?
Yeah, so I think, maybe you can have all the participants to have a very quick
Okay.
screenshot photo for the screen.
Okay, I will tell Mr. Gali to put all
Professor
the
Domain, if you don't,
participants. Yeah, for
Prof.
some
Domain,
of the
if you don't mind
participants. Yeah.
to
Like
have the picture
Yayang.
taken.
Mbak Yayang, please show your face, please. So we're gonna take your picture.
So if I can have everyone, all the participants to
Yeah, I already tried
put the
to
video on for everyone.
Or put the video
On for everyone.
on. Iya.
So we will take the picture.
Semuanya on, Kak, Pak. Videonya semua di on. Sudah.
Just for quick taking
okay.
picture.
Wait a moment.
I see Bupara there. Bupara, how are you?
Really, I didn't see. Sudah, okay. Bu Parawiyati.
Yeah, Bu Parawiyati.
Aku nggak tahu, yeah. To all participants, please, your camera make on because we want to take your picture.
Okay, are we ready? Dr. Kade, is it me
Yes.
or you who's gonna take the shot? Okay, I'm gonna
take the shot. You wanna and
okay, I'm just gonna take the shot then. I'm just gonna
no, this one. One,
okay.
2, 3. Or maybe you can take a screenshot for also, Pak Eka.
Yes. Okay. 1, 2. Okay, there are 5 screens, so if you don't mind, so 4 more screenshot. 1, 2.
1, 2, 3. Here from Indonesia, from Malang. I take a screenshot also.
Okay, 2 more screen.
That's enough, Mr. Eka?
Yes, that's enough. Thank you so much.
Okay.
I'm gonna submit this
Thank
to
you for the
AISFIS.
participant also. Good night and good evening.
Thank you, Professor Domain, for having this.
Thank you, Mr.
Thank you.
Professor Tomain. See you.
Thank you.
Thank you for Pak
Nice
Eka dan Professor Tomain.
Thank you so much for everyone.
I hope to visit someday.
Yeah, someday you can
You should visit, sir. You should visit.
visit Indonesia.
Thank you. Bye-bye.
Bye-bye, Mr. Eka, Mr. Tomain. See you.
Bye. See you. Bu Kada, terima kasih Bu ya. Pak Dekan, terima kasih. Terima kasih. Mas Gali, terima kasih. Terima kasih banyak Mas Gali.
Aduh, lungguh tumen paling lama nih.
Ya. Saya pamit dulu.